uh, interesting fall weather that we're having. Sorry for the very short notice again, but we decided to take advantage of some expertise that became available to us in the form of Bob White, who's a well-known immigration attorney in the area and who graciously agreed to answer questions about changes to the immigration system on a very practical level, since we are seeing our caseload kind of go off the charts right now in terms of immigration cases. In a previous virtual town hall, we talked about ICE raids and so forth. In this town hall, we are going to spend a little more time on certain changes to the legal immigration system that have happened under the Trump administration that are affecting numerous people at this point, and are very disruptive in and of themselves. Um, as you know, I'm here to help you, and whatever you need in terms of support, please call me at 847-413-1959. That's 847-413-1959. You can also email us at il08.helpline@mail, that's mail.house.gov. And you can, of course, visit my website at krishnamoorthi.house.gov. Let me just introduce our special guest, Bob White, who became available to us. He's been on speed dial for many people in the area for years. He's a principal in the Schaumburg office of the law firm Masuda, Funai, Eifert, and Mitchell, and co-chairs the firm's immigration practice. He was named Lawyer of the Year for immigration law in Chicago for best lawyers. And so for over a decade, he has been appointed annually to the American Immigration Lawyers Association, ILA, National DOL Committee. Just for those of you who don't know, ILA is kind of the gold standard organization that we send people to when people have legal questions and need attorneys. And so these folks do excellent work in referring people to people even who will perform pro bono assistance. And we, of course, will do our best. Let me get into it, Bob, if it's okay with you, and just start asking you some questions because we have so many already. I've lost count. um, okay, let me just start with this. First of all, can you give us, we have received numerous cases now. We've received 100 cases within days with regard to TPS, temporary protected status. As you know, the administration has moved to terminate TPS for Venezuela, Nepal, Honduras, and Nicaragua, and they've set the TPS expiration date for Venezuela for November 7th, so just in a matter of weeks. However, in the meantime, many people who came here from Ukraine in particular have seen their TPS dates now expire after 2 years. And that works a big hardship because they lose their work authorization and they have to reapply. The fee has gone from $580 to $1,000. And so there's a lot going on there. So if you can address this briefly, TPS, how do you how have you seen these cases be handled by the Trump administration? Have they been done in an expedited fashion, especially for people whose work authorization has already expired and so forth?
So, yeah, Congressman, first, thanks for having me on your webinar today. So, yeah, with TPS, there's a lot of litigation right now, and it really depends on the country. So, we always encourage people to go to the USCIS website because they do have a special page for TPS just to see what the expiration dates are so that you can prepare for the future. What many individuals on TPS are doing right now is if they are still in TPS, they are trying to change their status to another non-immigrant status. Many individuals are going back to school, applying for F1 status. So you really have to try to manage your TPS because the likelihood is the administration is going to completely eliminate the program at some point. Again, litigation dependent.
Wow. Okay. So just to be clear, TPS is a non-immigrant category. And so you are saying that people need to, if if they would like to try to change their status to another non-immigrant category, such as being a student visa holder or something like that. And is that something that the Trump administration is allowing to happen and doing so in a expedited fashion or a timely fashion?
So TPS is not a non-immigrant status, but there is guidance from the previous administration which allows for the change to a non-immigrant status.
Okay.
So they are actually granting some of these non-immigrant changes. Also, we've had people in TPS status applying for green cards based, for example, on marriage to a U.S. citizen, and those have been granted. Uh, Again, we're talking right now. We don't know what's going to happen in the future, but those applications are being filed, and some of them are being granted.
Got it. So just to be clear, it's not necessarily a non-immigrant status to be on TPS. However, people who are trying to convert to non-immigrant visa categories, presumably because it might be slightly easier than to do so to immigrant categories. Okay, let's turn to H-1B because again, we're getting a lot of questions on this. Okay, we just got some new guidance today on with regard to H-1B. As many of you know, the Trump administration is introducing a $100,000 fee, which I find deeply deeply problematic. Regardless, they're applying a $100,000 fee for new H-1B visa petitions filed on or after September 21st for individuals applying from outside the U.S. Okay, so maybe I'll ask you, Bob, just to be clear, this $100,000 fee does not apply to people who are renewing their H-1B who are currently here already?
That is correct. So between September 19th, when the proclamation was issued, and yesterday, there was a lot of conflicting information out there. And even the information which was posted on U.S. Citizenship and Immigration Services website yesterday is kind of there's basically four paragraphs, and the paragraphs seem to conflict. But the second paragraph is clear that if somebody is eligible for a change of status, to amend their status, to extend their status, then they're not subject to the $100,000 fee.
And they're not subject to the fee if they're changing from an F1 student visa to H-1B either. That's my understanding.
And that's correct, Congressman.
Okay, got it. Okay. How are the Trump administration's new extreme, quote unquote, extreme vetting rules and visa processing procedures affecting legal immigrants, students, and workers uh, currently here in the U.S. who are kind of applying for renewals or so forth? Like, what are you seeing in terms of the delay, for instance, in the processing times, so that people can take that into consideration as they apply for their renewals and plan their lives?
Yeah, so the current administration basically eliminated, there used to be an interview waiver procedure, which was eliminated. And because of that, and the social vetting that you mentioned, processing times are increasing. It really depends on the post, the consulate, where you're applying. The Department of State indicates their processing times on their website. They're updated basically monthly. And for many posts, it's accurate, but for other posts, especially the high volume posts, for example, in India, processing times are definitely increasing.
Okay. I got to ask you about that social media vetting stuff that you were talking about. What is some practical advice that you can give to people about social media and how that's going to be vetted, how that's going to be viewed, et cetera?
So Department of State hasn't provided the inside ball game,
Okay.
but just practically, you have to review your social media because you have to make it all public when you're applying for a visa, and the
Including
assumption
WhatsApp, including WhatsApp.
I would say anything because you're providing all your handles, so you're assuming that maybe not a person, but AI is going to be reviewing all these handles. So it's best to do some social media hygiene, especially before applying for a visa. And actually, going forward, you may want to think twice about posting something which may be considered to be controversial, not to you or your friends, but just to an outsider.
And does that include, I have to be frank here, does that also include for green card holders?
Um, I always say err on the side of caution. So right now, the social media, the extreme vetting, it's really starting with the Department of State, but I could very easily see it being rolled into USCIS for benefits applications, for immigration and customs enforcement. So just, rule of thumb is, think twice before you post.
Okay. The new H, I'm gonna bounce back and forth between different questions. By the way, you can submit your questions in the Q&A. I'll be honest with you folks, I'm getting so many questions. I apologize in advance if I don't get to all of them, but please, we'll try to address them from our office as best as we can. Okay, I'm gonna bounce back to H-1B for a second. Does the proclamation only apply to tech companies or really to all sectors, including the healthcare industry and to other sectors?
Yeah, so there were, at least in this guidance that was released yesterday, which again is 4 paragraphs, there were no carve-outs, except they did provide a procedure to apply for a national interest waiver. They did not provide a form. They provided some very broad criteria, and they said in extraordinary circumstances that a national interest waiver will be granted. And all they provided to submit the documentation to request it is an email address.
Got it. Okay, I've got another question here. Gold card. This Trump Gold Card program. I'll just tell everybody what that is. It basically was another executive order issued creating quote unquote a gold card path for wealthy foreign nationals who contribute $1 million or more to a Commerce Department fund to qualify for expedited green card processing. Okay, tell us about that. What should people know about that? Because we're getting a lot of questions about that as well. Of course, there's EB-5, which exists, but talk to us about this thing.
Yeah, so again, September 19th proclamation, not a lot of details. We've heard through the grapevine that there should be more details by the end of December, but we've heard so far that for individuals it's $1 million plus a processing fee. For corporations, it could be $2 million. Yeah, a lot of details still to come. And also, this is not statutory, so we're not sure where the authorization will come for this, because the administration really just can't pick and choose from the 140,000 green cards that are allocated each year for the employment-based categories. some speculation is they would classify somebody who's eligible for the gold card under one of the current categories and approve it through that. But again, we don't have those details.
Okay, so maybe I'll just ask a dumb question then about this gold card thing. Is it real? Is it for real, or is it just like a concept that's out there and it doesn't really have any practical impact today? You just have to continue with the whatever current EB-5 program is or anything like that. In other words, let's say somebody is like super desperate who's in, I don't know, they're in TPS and their work authorization is about to end, very shortly, but somehow they're able to get resources to be able to get into another category. Is this even something that is it for real or is this just a concept?
Uh, as of now, I would say it's a concept until we get more details. And then if the administration tries to pull some of the 140,000 from other categories, which are backlogged, I'm assuming there'll be litigation there.
Right.
So, because it's somebody trying to basically
Right.
jump the line.
Got it. Yeah. Well, I find that whole program very problematic for various reasons, including that I think it could be susceptible to abuse. And I think someone could, sponsor somebody for $1 million and all of a sudden that person is like an indentured servant or something like that. And I'm very concerned about the rules surrounding these things. Okay, let me talk to you about another issue. Enforcement of fines for green card holders not carrying papers. This is now apparently an issue under Section 264 of I guess, the Immigration Nationality Act. You need to carry your papers. You need to carry proof of registration and a green card. Normally in the past, people rarely do, and it's not been enforced. But apparently now there are some enforcement actions. There have been fines, and in California, reports of fines and potentially imprisonment for not carrying your green card. Is this true? And what's your advice here?
So this starts getting out of my area a little bit, which is the business area. That starts getting into the removal area. When you start talking about, penalties from ICE, et cetera. But we always encourage, with the current administration in particular, do carry either your documents or a copy of your documents in case you are stopped by ICE, the FBI, Department of, there's a lot of different government agencies in this area right now. So you just want to be able to prove your status if requested.
Got it. I have another question here. Are people safe to travel internationally with a green card if their travel documents have not been renewed? Well, in my opinion, don't travel. Certainly, if don't travel internationally uh, unless you have a green card and unless everything is timely and nothing is expired. Um, if you even have an H-1B or something like that, I think you have to be super cautious right now, given everything that we know about CBP at the airports and so forth. Bob, do you disagree?
No, I don't disagree. And also, there's travel bans out there. Really, if you are going to travel internationally, you may want to consult with somebody to make sure that there are no impediments. And then, even if there are no impediments, it's a risk-benefit analysis. Again, the level of scrutiny is just much heightened right now.
Okay. I agree. How about student visa holders? Are you seeing, I know that there's a lot of talk about student visa holders having a hard time getting interviews on time to come here and matriculate for the start of school. We have a bunch of cases of people who are kind of stranded in their home country, not able to come here and matriculate on time. Uh, what are you seeing? And is it just a matter of delay? And so they'll eventually just make it here. It's just going to be longer than it took. Or what are you seeing right now?
There were a lot of students impacted. There was about a month where they were not processing any student visas in order to roll out these new extreme vetting processes. So that created a backlog. And then once they did start processing visas again, with previous administrations, they did expedite F and J, the student visas. And with this administration, expedite requests are not being granted. So there were a lot of students who were impacted. So you can apply for an F or a J visa up to a year ahead of time. So talk to your school to see if they would be willing to issue the I-20 form or the DS 2019 way in advance so that you have sufficient time to apply for the visa. The only thing is, though, if you are given the visa, you can't enter when you receive the visa unless it's within 30 days of the program start date.
Got it. Got it. Okay, very good. And I think that in some cases, some universities, knowing the delay, are allowing people to take classes online until they're able to come here physically and so forth. Um, okay, let me ask you about OPT. Can you tell us a little bit about optional practical training? I think first of all, you should probably just tell us a little bit about what does that mean and what are you seeing in terms of changes for that?
Yeah, so F1 students are allowed 1 year of OPT on each higher level of education. And then there's a second OPT program, which was actually rolled out in 2008, which allows for an extra 2 years of OPT for individuals who have graduated with a science, technology, engineering, or math major, a STEM major, and they're working for what's called an E-Verify company. Adjudication times have increased for OPT. They do offer premium processing through OPT. So many students are being forced to use that because they do have a job that they want to start on time. Also, the level of scrutiny is also increasing. So USCIS is issuing more what's called requests for evidence. And many of those are just to prove that they've been maintaining status.
Okay. How about seasonal workers? We get a lot of requests for seasonal work visas to come here, including, to come here. And there are various types of seasonal programs, including for agriculture, but also for even working in our summer, amusement parks and so forth. Can you talk to us a little bit about those seasonal programs and have they been affected at all?
So for agricultural, it's called the H-2A program, and for the non-agricultural, it's the H-2B program. The H-2A program, it seems like with every administration, there's some challenges with the program. The current administration is trying to streamline the program as much as they can. So before the government shutdown, the Department of Labor and USCIS were basically going to start working in tandem to try to expedite H-2A applications. On H-2B applications, there is a quota, but Congress pretty consistently for, 7, 8 years has increased the quota just because there's such a demand for temporary workers in many of the industries that you mentioned, Congressman, and many others. So, but the programs are complicated. So you really have to dot your I's and cross your T's just to make sure that you get your workers here on time.
Got it. Okay, how about this? How does an arrest history without any conviction affect somebody who is going through any of these, visa processes or change of status situations? I mean, what are you seeing now? Like we have, we've received cases where, somebody was they were arrested, but then the charges were dropped, uh,
Mhm.
and or there was a misdemeanor charge and it was dropped. I mean, just let's set aside the conviction situation for a second, but just looking at the arrest situation, tell us a little bit about that. What are you seeing? How does that affect people's ability to renew status or change status or anything like that?
Uh, so what we are seeing is the USCIS is issuing a lot of requests for evidence to have biometrics taken. And then the applicant has to go into a processing center, have the biometrics taken so that USCIS can confirm whether, there is something more extreme that has occurred with that applicant.
When you say,
Also,
but sorry to interrupt, when you say biometrics, they're talking about fingerprints and stuff like that?
yeah, fingerprints and photo.
Okay, sorry, go ahead.
Yeah. So then, uh, if nothing comes back, if it's a simple arrest, then the application may be approved. But students in particular were greatly affected by this in March and April. Their records were being terminated when they had simple traffic offenses. So we believe that AI was just pulling all of these records and then the arrest and criminal records, and then terminating their called their CBIS record. So there was a lot of litigation about that, and ultimately those CBIS records were restored because a CBIS record should not be terminated just because a student gets a traffic ticket.
What is a CVIS record again?
So CBIS is it's a system that is run by Immigration and Customs Enforcement, which manages F, M, and J students. So uh, really the F, M, and J categories are the most highly scrutinized, regulated categories because there's so many reporting requirements that have to be done through the system. And if a student isn't doing what he or she should be doing, then their record is terminated. And theoretically, then Immigration and Customs Enforcement could pick them up to start deportation proceedings.
Got it. Okay, I have another practical question regarding TPS from Venezuela, because that one is going to expire. I guess there were two termination dates, October 3rd and November 7th. Regarding TPS from Venezuela, if you've submitted to change the visa type and it's in process right now, how does the termination of TPS as of October 3rd or November 7th impact your status?
Well, you should be allowed to remain in the U.S. if you have an application pending. If the application ultimately is not approved, then you have to depart the U.S. But while the application's pending, you should be allowed to remain in the U.S. Now, if somebody's changing status from TPS to F1 status, the premium processing service is available, and a lot of TPS beneficiaries have been taking advantage of that just to, try to manage the uncertainty.
Got it. Okay. Let me ask you kind of a more practical question here, which is, I guess, um, how are you counseling people whose like work authorization is about to expire and uh, like a lot of our Ukrainian families, for instance, they got TPS and they got work authorization. They're about to expire. How do you counsel them? What should they be doing? I guess this applies to anybody, but like what is the best policy and how do you work with your employers and all that stuff?
Well, working with the employers is actually a separate issue. You're trying to maintain status however you can. So that's why if changing to some other status is a possibility, you should take advantage of that. But if, let's say, you change from TPS to an F1 student, then you may not have employment authorization anymore. So then the employer is going to have to release you. So, you're just looking at the big picture, and what the ultimate goals are.
Got it. Um, Another question that we got is, uh, basically, are you seeing are you seeing at the levels of the State Department, USCIS that routinely kind of work on these types of issues? Um, are you seeing any kind of different approach that they are taking that's been influenced by the administration that's somehow more restrictive even within their discretion? Or are you seeing them go to the full extent of whatever discretion they have to continue practices as they were from the prior years? How do you see that kind of playing out as well?
Uh, so there definitely has been an increase in requests for evidence, notice of intents to deny. Uh, when people are applying for visas abroad, there's been an increase in administrative processing, so visas are not, issued right away. So the administration is being, much more aggressive in the legal sphere, in addition to, the other spheres.
Yeah. Well, we just have a few minutes left. I'd like to um, ask you what kind of practical advice are you giving kind of more generally to people right now as they kind of confront all these changes that are happening simultaneously across so many different areas of the immigration system? Any kind of best practices or tips that you have as people are going forward? Obviously, each person may be in a slightly different situation, so they need to consult with their attorney or talk to us or whoever about the specific rules. But any kind of more generalized guidance that you have.
So you really have to know what your status is. And also, the government doesn't reach out to you when they propose to change something. So, for example, if you're an F or a J student, the international office reaches out to you with updates. You have to read those updates because they are trying to help as much as possible. For other statuses, sign up for, updates, immigration updates. A lot of the information may not apply to you, but for example, this H-1B $100,000 fee guidance that came out yesterday, you really have to review and understand if it applies to you. And if you think it applies to you, then you do have to reach out, to either your office, Congressman, to the attorney's office, to find out, how you're going to be impacted by that.
So it's like stay abreast of exactly what's happening with your status. Obviously, you might be concerned about all different statuses, but with regard to yours, make sure that you're on top of it and stay connected to people who are monitoring what's happening. I guess my kind of parting thoughts on this are always follow the law. Whatever um, situation you're in, make sure that you follow the law and you get counsel wherever you think that um, there's some ambiguity, you have questions. It's extremely important that you have counsel to help you get that legal advice to deal with your particular situation. Second piece of advice is you should come to us anytime if you have any questions, and we will also try to help you as much as possible. My number again is 847-413-1959. And you can also email me at ilo8 .helpline@mail.house.gov. And of course, you can go to my website. Um, Regardless, um, we are here to help. I know there's a lot going on so many fronts. And as you know, before we had a town hall meeting just to talk about ICE raids and knowing your rights and so forth. At all times, just know your status. In this case, know your status, ask questions, and proceed accordingly. We're here to help. Any parting thoughts, Bob?
Unfortunately, I'd like to say that, everything that is going to change with this administration has happened already. But unfortunately, I think there's much more to come. So, and much of it will most likely not be positive. So, again, like the congressman was saying, definitely stay abreast of, all the changes because some or many of them may impact you.
And remember, there is litigation that's going on too in the courts. There's various, whether it's the $100,000 fee, which is being litigated right now. I believe it's illegal. It's not in statute. I believe it's illegal. All that being said, you can contact us. We'll try to explain our understanding of the latest, and also try to make referrals as necessary. With that, I just want to say thank you again, Bob White, for being with us. Thank you to all of you for tuning in, and look forward to talking again soon. God bless. Thank you.